Unlocking doors to your dream home. Keys to the Castle takes you on a real estate journey like never before. Welcome to the podcast where every key opens a door to possibilities.
Welcome back, Castle Dwellers, to Keys to the Castle. Today we're diving into the latest updates shaping New York's real estate scene, with a special focus on the recently revamped property condition disclosure statement. Joining me, as always, are Jason Kleiger, our real estate attorney, and Jason Marcus, the mortgage pro.
Hey.
Let's unpack the biggest update. The mandatory PCDS, property condition disclosure statement. Previously, sellers could opt out by offering a $500 credit to buyers. Effective March 20th of 2024, that option is now gone. Completing and delivering a detailed PCDS is now mandatory for all residential property sales. He's already shaking his head, except for a limited number of exceptions. Gentlemen, welcome back.
Thank you, Bisendra. I think I would like to start this off.
You didn't wait.
Oh, yeah, it's like right out of the gate. It's like I was strapped into the bull and I just opened that fence. Here we go.
Now, this is the attorney's worst nightmare. Maybe not for a buyer's attorney.
But why?
Okay, so the PCDA, Property Condition Disclosure Act, came into play. And, basically in New York State, you had the option as a seller of giving a $500 credit to the buyer in order to not disclose anything you may or may not know about your property. Now, that may include the foundation crumbling, abandoned oil tanks, radon, lead. It runs the whole gamut. And as an attorney who would represent a seller, I don't want my client to fill that out. Why would I want my client to fill that out and say, hey, buyer, please rely on this itemization that I'm doing here, and say, hey, there's no, foundational problems. Okay, well, what happens 6 months from today? What happens 6 months from today and there's a giant storm that we've never had before? And let's face it, we've had giant storms that we've never had before.
Mm-hmm.
Okay,
More
we've had Sandy, we've had Irene, we've had the floods in Queens. Okay, and now all of a sudden your buyer, who you said, thanks for the money, goodbye, to maybe, 6 months ago?
6 months.
Maybe even a year ago? And says, hey, you never told me about this. And you were supposed to. That doesn't make sense. Everything. Deed crosses the table. That's it. That's my liability. You give me the money, deed crosses the table, I give you ownership. But now I have to tell you everything about my house. And that means, easiest thing would be, I don't know. Okay. There are different options. I don't know. Yes, no.
But, hold on. It's 50 some odd questions.
I've
read it. I've read all of them, but I'm just saying it's 50 something questions, right? I don't mean to cut you off. I know you're heated up. So
I'm fired up right now.
So
yes, go ahead, Bisendra.
I just had a question. So I'm looking at, because I have notes specifically for you, which I don't normally have.
Right. You're ready.
I'm ready for you today.
We need this info.
Right.
The world needs this.
So the seller has to, for those that don't know, the property condition disclosure is something that an agent normally gives to a seller when they're selling their house.
Mm-hmm.
Okay. And the seller has to fill this out to the best of their knowledge of anything wrong. Let's just call it anything wrong that they know of with the property that they are selling. If they don't want to disclose anything, their attorney advises them, don't fill it out. Mm-hmm. We'll give them a $500 credit and it all goes away. Right? That's what you were just talking about. At the closing table, you get your $500. The seller washes their hands and everybody goes about their merry old business.
That's right.
Okay. So now they're changing it.
Yep.
That the seller is no longer allowed, or a seller is no longer allowed to do this.
That's correct.
So
why is it a dagger into my heart?
Oh, yes. Tell us why it's turning the dagger slowly.
So if I'm representing a seller, all the seller has to do is give $500 to the buyer.
Right.
And not have to fill that out. And the liability action, and this is, as an attorney, we always have to focus on the liability.
Right, because your job is to protect your client.
Exactly.
Right.
And how I protect my client is I say, you give that $500. And I've had clients say, oh, I don't want to give that $500.
Oh.
And then I say, well, I'm not representing you. I've done that before.
Really?
Yep. I have refused to represent clients who will not give that $500 in order to not fill out that statement. And they've always gone back. They've always said, oh, okay, you know what? You're right.
They figured it out.
Yes. That's how important it was to give that $500 and not fill out that statement. And you don't want to get into court, into the battle of, okay, what knowledge did you have? Okay, what actual knowledge did you have? Okay, you saw that at one point during your 45 years of ownership, you had water coming in. So why did you not disclose that? Okay, maybe that person is somewhere else in an estate, or maybe that person is, has a power of attorney, and that person just either doesn't remember.
Well, wait, how are we supposed to get, in the case of something you just said, in the case of an estate, REO, specifically in those situations where the owner, the actual physical owner, is an entity, who is responsible for signing that, and how will they be held accountable in the event that the disclosure is not completed?
Well, luckily, with estates especially, okay, because with estates, you don't, you're exempt.
Wait, before you continue, I'm going to read our
do.
disclaimer. This episode is for informational purposes only and does not constitute legal or financial advice. Always consult with qualified professionals for specific guidance.
I'm not signing nothing.
It's a scary time. Since I've been practicing law, there's always been the $500 and not having to fill out the PCDA. And, I'm also licensed in Jersey.
Right.
I'm doing 2 New Jersey deals right now, and there is no law like that. And people fill out that form, a giant form that says, they don't know about anything. But at the same time, you're talking about and I brought it up before, but do you really want to go to court and say, no, I didn't know about this? And how are you going to prove a negative?
Well, isn't that what the whole, I don't want to assume. Logically, knowing what I know, there is really no benefit to the seller to complete this form. Because if they fill it out honestly, to the best of their ability, they don't know the condition of the property is in, because the average homeowner does not know until something breaks.
And, that's the trap. Okay.
It's a trap.
It's kind of like a trap, because, some brokers say, fill out just, I don't know. But that's the trap. Because
where does the home inspector get involved in this whole thing?
The home inspector
is the professional who's actually looking for these.
That's things. A good point, Mr. Marcus. Right? Because if I represented a buyer in a transaction, we've discussed this at length. I encourage them to get a home inspector, a very good home inspector to come in and go top to bottom. They do that. They get a report, and any findings that are abnormal get addressed at the signing of the contract before any good faith down payment is made, before any contract is signed. So how is that still an issue for the seller? Mr. Marcus made a very good point, because there's a third party intermediary saying there's nothing wrong, this is wrong, and it's addressed. So
in the case if they just...
I'm playing devil's advocate. You see it turning red, right?
Oh, I'm loving it. So recently, and in New York deals, I've had 2 deals. Okay. Same inspector, I won't name the company, didn't do a termite inspection, didn't do radon.
Some of those guys aren't licensed for those things.
Yeah.
Exactly that reason.
Exactly. And
lesson learned for that audience listening out there, make sure these guys are certified in the things you need them certified in.
They call them WTI, WDI, wood destroying insects. And always make sure that your inspector has that certification, or if not, that you get an inspector in addition to your engineer, inspector, that does have that certification.
Because some loans require it, but the conventional loans will not require it unless it is very obvious and evident that there's damage to it. And as we know, a lot of times it's not that obvious.
Yeah, a lot of it's covered.
Yeah, but you know what though? an inspector will only do so much and is on the side of the buyer. Okay. So if the buyer says, hey, I have this whole report and it shows me X, Y, and Z, they're not going to say, oh, the electricity is fine. Oh, there's no radon. Okay. A lot of inspectors on Long Island especially don't care about radon. It's upstate. Okay. Upstate, Rockland County, Orange County, they love, well, not love, but they hate radon, and they will inspect for radon. And what do you know? That's on that form that we now all have to fill out.
You got to be shitting me.
It is. And unfortunately, if I'm representing a seller, okay, I actually have to go through that and make sure that if they know that they did have a radon problem, or they currently do have a radon problem, that they have to disclose it. Because if they write that they don't know, okay, then they're liable in the future if the new buyer finds that there's a radon problem. Okay. And here, as an attorney, what I've been thinking about is an exculpatory clause for me, because this is a big liability issue for me. Because if I have a seller who lies on that statement or doesn't fill out that statement truthfully, I guess that's the same thing. Mm-hmm. Okay. I have to now say, okay, seller, my client, you are filling this out to the best of your knowledge. I know nothing about the house. Okay. If you get sued because you lied on this form, I am not liable because I told you to truthfully fill out this form. And it's scary for me because I know that if a seller gets sued after closing, which is the worst nightmare for a real estate attorney, if a seller gets sued after closing, they're coming after me.
They are coming.
I got multiple questions. First, I want to know where attorney-client privilege comes in regards to them telling you something and you still being liable, but under that umbrella of that privilege.
Well, it's a privilege that can be waived. It can be waived in the sense that now I have to defend myself. Okay. I can't say, if someone, if I'm in a civil lawsuit and they say, did you know about this? And if I'm being sued by my former client, okay, I have to defend myself. What am I going to say? I'm not going to answer that question for attorney-client privilege. And they're going to say, oh, okay, so, we got a judgment against you.
What?
Now, my second question, how long is the statute of limitations for the seller after they close? Like, when does it end? It can't just be forever.
My belief is that it is, and like I said, everything is fluid right now because they just, this is something that New York State and the legislature thought was a brilliant idea. So everything is still fluid. No one has been brought to court. No one has really interpreted that much of the law. But, I would assume that it's the same statute of limitations for torts, because this would be a suit in torts. You could claim that it's a suit in contract because you could say, okay, well, when they filled out that form, that it actually is part of that contract. But again, because it's so fluid, do we know that it's part of that contract?
Actually, yeah, I don't think, I agree that all the legal aspects of it are still fluid, but that is technically, from the guidance I've been given about this form, is, other than I give no guidance on the form, right? I'm not allowed, and I should not give directive as to how to fill it out, only but to fill it out.
Mm-hmm. Right. Mm-hmm.
Okay. But it's being filled out before there's the existence of a buyer, before the existence of a contract.
But if I'm
right, so I don't understand.
But
actually, let's not go too far that way, because that's after the fact.
But listen to this: if I'm buying your house and I'm relying on your assertions and I'm relying in my detrimental, not capacity, but to my detriment on your assertions on that sheet, obviously I have some recourse if you deceived me.
But then,
The burden of proof, though, like,
yeah,
it's going to be really hard.
I love playing devil's advocate, right?
that's-
But on this instance, I want to take the pro position.
Mhm.
I'm a seller. I'm selling my house. I listed it with Bisendra, and right,
That guy's awesome.
that guy. I love that guy.
Oh, my God, what a great agent.
He's
he
the
always
best.
uses the
He's
best.
the
His
best.
team is awesome.
Oh, so much.
His mortgage guy and his
Mhm.
attorney.
Mm.
Phenomenal.
What a team. What a team.
The looks.
Yeah,
Oh.
stunners those three. So
He's the only one that has hair.
hopefully for a while. So, and to the best of my ability as a seller, I fill out this form.
Mhm.
To the best of my knowledge, there's nothing wrong with this property at the time of sale. Say they moved in and they hit something, or they did a renovation, and it happens all the time. People do reno
Yep.
because they watch all this great reality TV and they want to do all these phenomenal repairs under budget because they're now DIYers.
Of course.
They do something with an AC line for their AC condenser. Now the AC is not working. Now that's leaking. Now they have a mold problem.
Mm-hmm. Mm-hmm.
And they said, you know what? That's the seller's fault. How is that my fault? Because it's going to happen. Because they're going to say mold happened and that mold was pre-existing. I'm just giving, I'm trying to make this worst case scenario.
As we discussed in previous
Yeah.
podcasts, anyone can sue anyone for anything. And that still happens without having to do away with the PCDA form and the $500. That still happens. What do you think is going to happen when you open that floodgates and you say, there it is, right
I
there.
have proof.
They did not know about they did not know about mold. Okay. But here it is. They should have. Okay. They hit it. It's a latent defect.
Right.
And what a latent defect is basically that this is a defect that should have been known or was known to the seller, and they did something to hide it. Now, in New York, you could still be sued for a latent defect. All right. Even if we hand the deed over, we give the $500, we don't have to fill out the form, you could be sued for the latent defect. But the form will just give more ammunition to sellers for that, to sue upon a latent defect.
This is nuts.
Yeah, I want to cry right now.
Yeah. No, because we're all in the position of protecting our clients.
Correct.
Yes. Well, do you want me to hit it from the buyer side?
One second. I gotta wrap my head around this. Full transparency. I've never filled out one of these forms for my seller
Mm-hmm.
because my mentor told me all you do is put the property address in there. Do not even put the seller's name.
Mm-hmm.
Put the property address on the form and hand it to them. Tell them, fill it out. This is way before this whole act.
Yep.
Tell them, fill it out to the best of your ability. If anyone asks, if there's ever a time someone asks you for this, go to the top of your fridge, take it off after you've completed it, and hand it to them. The only person that should be asking you for this is your attorney, right? But always hand it to them and let them fill it out. Never do it. And I'm saying to myself, but why? Why can't I just sit there? I'm holding their hand through everything else.
Mm-hmm.
So my mentor was my father. So he used to tell me, no. He's like, no, you don't do it.
Nope.
It's not your job. Your job is to provide them with the documentation required, and then you walk away. Let the attorney handle it after that. Look where we are today.
Yeah.
So now these 50 some odd questions, I didn't read the radon part. So that's especially concerning because radon requires a special test.
Yep. Its own test. Yep. That you leave there for like a week.
Right. Listen to this. So most homes now have a combination smoke alarm, carbon monoxide detector. A radon detector is a completely separate
Mm-hmm.
item that you have to purchase. I can almost guarantee no seller is going to write that they know that their property has radon because they don't have the necessary equipment to detect it.
And that's completely true. And, you mentioned the 50 some odd questions and radon is just one of them. You bet that sellers don't think or know or have the means to know about 15 other 20 other questions, and which is scary because it does expose them to that liability. And, you like I said, radon is just one of them. And someone like an elderly person who's lived in the same house for 50 years, okay, she or he might not know that there are other problems there just because they haven't been to the basement in 20 years.
Yeah, because probably they're physically unable to do so.
Exactly. And they still have to fill out the same form as
Everybody
investors, okay,
Ah.
who build from the ground up, okay? The only thing that's there is the foundation.
The foundation.
Okay. And you're expecting, Meemaw to fill out the same form accurately as an investor? To me, that just, it doesn't make sense. And it opens exposure. And, the litigation people are probably licking their chops right now.
Yeah, they're getting ramped up. They're like, wait a second, this is going to hit the floodgate, and then we're all going to.
But I'm going to have to do a cover your rear end letter every single deal when I'm representing a seller. I'm going to say, you filled this out. I had nothing to do with this. You're filling out to the best of your ability and the best of your knowledge. And that's it. I did not advise you on how to fill it out. And that'll at least give me some protection,
Yeah, but how much
I feel
was
bad.
That? Yeah. Okay. So on writing those feelings,
yes,
right?
Yes.
So my primary focus when I deal with seller clients because I'm a listing agent, seller agent, however you want to phrase it, and I walk them through the process. They're going to come back to me after I hand them that document because they're going to ask me, why do I need to fill this out? Question one, why?
Yep.
Oh, my cousin's uncle's daughter's best friend told me that I can just I don't have to fill this out. I'll just give them a $500 credit. No, that's gone.
Yep.
When has it gone away?
Yeah.
March 20th is the date. So all active listings on that date that are not in contract prior to the date of March 20th will have to complete this form and everything that on or thereafter, correct?
Mm-hmm.
So so as a seller's agent, do I need a CYA too?
When you're practicing law in a small firm or in your own solo firm, things get a little bit more risky, I guess you could say. Not risky, but, there's more at stake. As a seller's agent, I would make it clear. And I would say, this is based on your knowledge, not my knowledge. I don't know this house from a hole in the wall. However, I have to give you this form.
Wait.
Uh-oh.
Wait, you just made the most sense. I've been talking about this thing for a week with people in my office. I will physically have previewed the property and physically been there. You will never go there. Neither one of you will never appear. You will never touch that block.
Almost never. They say they're going to invite me to the barbecue. I never get the invite.
Dude, you get invited.
I never get the invite, ever.
Okay, I want to make sure.
They always tell me I'm coming.
I'm going to make sure.
Always fired up, and they're always like, Jay, you did awesome. Where's my invite? I want the steak.
I got it.
I want the steak.
I'll remind them.
Get the good meats. Don't get like that. Half
the juntas.
I don't want to. I was just gonna say a store, but I was like, wait, no, don't do that.
No. We could all rag on Key Food.
No. Key Food has some good cuts, man.
Not Key Food on Queens Boulevard in Forest Hills. No way.
These guys are like,
I will
drop an address.
And if you want to let them come after the manager, it's like, whoa,
let them come after me, man.
It's like you're not worried about that liability, but you're worried about this. Like what?
Yeah. Come after me.
He's gonna wind up with a whole rump roast on his doorstep now.
As long as it's fresh.
Here's your pork shoulder. Son of a.
Yeah, that won't be kosher.
Yeah, I was just gonna say this is the kosher network over here.
Okay, wait. While I try to compute this, Mr. Marcus, please tell me there's some benefit to the lender in all of this.
Yeah, the benefit is that Jay has to deal with this and I don't. That's the benefit to the lender. It's like I have no worries in the world. I literally am representing the buyer. They have all the leverage in this situation. It's like I'm on the right team.
Yeah.
Finally.
Oh, shit.
Finally on the right team.
Yeah, so he's actually clean on this.
Yeah.
I'm great.
I mean, well,
I'm pointing the finger.
Yeah.
It's like, it was you. You had radon. Nobody in Long Island had radon. You did.
Mr. Marcus, what happens if you get contracts? Okay, we're in contract. I give you the contract. You draw up the deal. You get a contract, and let's say this is attached. As a rider, as a side agreement, whatever. Okay, and you see that the seller filled in basically everything that's wrong. Would that affect your ability, or would you kind of say, all right, well, this is the new norm?
This is where this gets interesting. Okay. So in my world, everything is really about what the appraiser is pointing out up until the point where there's specific language inside a contract that the attorney is forcing the hand of the bank to basically almost follow up on. So just bear with me and I'll walk you through it. Like if all of a sudden there is a rider on this contract, which requires 5 things to get fixed, the bank is going to need something in writing from their client that these things have been rectified before they're allowing that to close. So a lot of times, like, that makes me that's the only part that kind of makes me like unhappy, where it's like, okay, now I'm at the mercy of something that needs to get repaired that has to be validated before we're able to close. And now I'm at the mercy of whether or not the sellers are going to do it. Mm-hmm. And sometimes it might be so simple that I'm getting held up on something ridiculous like a cracked window. But if it's listed, my underwriter is going to come back and it's like, where is the confirmation that these things have been repaired? So that's the only time where something like this can kind of start getting into my wheelhouse.
So, with you saying that, I'm going to see I'm projecting a lot more escrows for repairs. So how would banks handle that?
Generally, when it comes down to it, it's like if there is going to be escrows for repairs, it's been in my experience that the bank usually calls for 1.5 times the amount of what that repair is. And then I go down a different road. Now I'm going to have to get a licensed professional that actually repairs these things to give me a invoice to show me what this is going to do. So that way I can bring it up the ladder to get that escrow situated for closing. So it does get more and more convoluted on my side when that's not handled, or if it's being handled inside the contract of sale.
And that kind of brings me to, and now Bisendra, I don't know if you've had some schedule on your agenda here, but that kind of brings me to representing a buyer and how I feel with the PCDA and the $500 going away on my side as representing a buyer. Now, if you kind of think about this, it's kind of like an inspection report, but it's also filled out by the seller. So at the same time, you kind of have to take it at face value. And as the buyer's attorney, I would say, yes, take a look at this, take it at face value. You can't really trust what they're saying 100% because, what are you going to buy from Mr. Good Guy, like, Mr. Rogers in his neighborhood? There you go. So, so it's not an inspection. It's not you can't treat it as a certification from the seller to the buyer. You can't treat it like that. And part of me, would say this is a business decision on a client's part. If I show you this, well, I will have to. When I show you this is what they fill out. Remember, they're trying to sell a house for a top dollar, but this is a business decision. Take a look at this. And, if you would like to move forward, we can move forward. And what that gets me is a sense that if they do move forward, if they say, hey, you put this out there, you gave me the disclaimer of what to expect, what not to really, trust in this. I have my inspection report, okay, and I'm going to go through with this. I don't make that decision for clients. The client makes that decision for the client.
And that's key. Because a lot of people try to skimp out on the inspection part.
Oh, God, don't.
No,
do
they
that.
really try to go cheap on it.
100%.
I see it day in and day out. Do you have someone cheaper? I call the 3 that you get, and I give them 3. Call them, work out that. Tell them what you want and what you're concerned about. They're going to come do a full inspection, and then they're going to address all your specific concerns, right? And they still want to cheap out.
Yeah.
But when you're using qualified professionals that will give you all these things, hit all the nails on the head that you want, single largest purchase that most people will ever make, you want to worry about $50, $60, $70. Even let's just even call it $200 difference. I'm prepared, even before this whole PCDA thing, I'm prepared to pay the extra money. Because when I get that report, I want everything. Like Bridget, Inspection Boys, you weren't here that day, but we'll bring her back. She runs her business like a well-oiled machine. She wants every nook and cranny done, every outlet done. She wants okay? And that's what you want. And I think, correct me if I'm wrong, she said that she does termite inspection with every inspection.
Yep.
So we'll bring her back to discuss all the other finite things like radon, because I'm really curious about that radon thing. But people just remember, do not skip out on the home inspection. Do your research, get everything done. So wait, that reminds me. Okay, so should I get an exterminator to do my termite inspection? Would that be more beneficial, do you think? Just forget about what we know professionally, just from an educated standpoint.
I mean, we live on Long Island, and we know that, like, basically it runs rampant.
Yeah.
So, like, if I'm buying a house in Long Island, I'm talking to the seller about, like, treatments, because there has to have been a treatment at some point in time done. If they're not treating, I'm not going to be surprised if termites are popping. Like, it's just, we live in that place. But just to kind of counterpoint what you're talking about, we know that we're not going to have radon sitting in the bedrock, because just the way that Long Island is. So, like, you're not going to see that. So, like you were talking about, we're talking about Rockland County, and when I'm doing upstate, like, that's more, it's just really comes down to the earth itself and, like, what you're sitting on. But we know it's just like, if there wasn't some sort of treatment done on termites, it's almost a foregone conclusion there's going to be wood damage from some sort of, be it a carpenter ant or a termite something's popping. But I have a couple of other things where I got to ask you, as a buyer's attorney, what would you say the amount of times you actually review a home inspection? Like how often does that happen?
In the past 2 days.
Breath for that one.
If you didn't see that, like,
there was a reason I was a little late today. In the past 2 days, I've actually reviewed with clients 5 different, inspection reports. Now, that may seem like not too much, but
they're detailed.
They are detailed.
Very detailed.
And, we're talking about like 70 pages here and there. And each client wants something different. And when you have a client, you might have the client that wants every single thing in that inspection report fixed. Okay. And then you might have a client that says, you know what, I can take care of that. I'm pretty handy. So just the first 2 things. And when I say the first 2 things, they're usually like in red and bold, saying, this needs to be fixed right away. There's a cracked window. Okay. But when it comes down to it, you kind of have to remind yourself that it is a business decision. Okay. Just like I was talking about earlier, these are business decisions for clients to make, saying, hey, well, here are the issues. Do I want to lose my credibility with the seller and claim that I want 25 different things repaired? Or do I want to say, hey, it's a tight market right now. Okay, there's no inventory. I want to make a strong offer. I just want these 2 things fixed. Okay. And those are the items that generally are important to people, and it doesn't lose your credibility, and it's a business decision. I will never say to a client, that's not important. Don't worry about it. Or, you know what? That's only going to be $50. Okay. Cause I'm only an attorney. I'm not a handyman. I'm not a painter. I'm not an appliance repair person. Okay. So these are business decisions that you leave up to the client. And yes, if a client wants me to go over a inspection report, I will go over it to a degree. I will not go over the pile carpet having, one piece missing, or, a little dent in the side of the house. Okay. I will go over the main things with them.
But now you're going to have in your right hand the home inspection report. In your left hand, now you have this seller's disclosure. Like, I'm guessing that you're going to have to sit there and almost crisscross to check boxes on each side to get to a point where it's like, okay, here's something that's popping in this inspection report that the seller's saying they didn't know about. So like, that's where, and the other question winds up becoming is like, what does the things that the home inspector basically puts on their form in conjunction to what the sellers are saying, like, where does that line get drawn where it's like, okay, this is where that person is liable and not liable, and is the home inspector? Like, it's just, it gets so convoluted. I just don't know how you're going to be able to have hours to do your job anymore.
I can answer your question in one sentence. Go with your home inspector over the PCDA by the seller.
Easy.
Easy.
Just that easy.
Just that easy. Okay. If they,
But
here I go over one sentence.
No. But I'm gonna incite you to go over. So, in some cases, I accompany as the buyer's agent. When the buyer is my client, I will attend with the buyer to the home inspection and be present. Mm-hmm. In some cases, the buyer is not able to attend physically, and I am still there. I feel like that's going to be a problem for a buyer's agent.
Well,
because I'm putting myself in the line of fire.
You're not. When everything comes to push and shove and there's a contract out there, okay, it's up to the actual buyer. Okay, there's a exculpatory clause for agents out there that there is no representation about the house. There's no representation about any setups. There's no representation to anything about the house. And that goes for all realtors. Okay, that just, now buyers can't make inspections a lot. And you know what? Inspectors love that. They like going around.
Yeah, they shoot through it.
Yeah, because not only shoot through it, but, a lot of times you have buyers that follow the inspector around. Yeah. And the inspector will miss something. And Bridget, spoke about that. And so it's while it's disheartening and almost kind of like discomforting that you're the only representative of the buyer there, it's still exculpatory in the contract. And to be honest with you, whatever's in the contract, whatever it says, and whatever someone signs kind of cuts off any, I guess, assertions, liability, not liability if there's a latent defect, but assertions, any kind of representations made by anyone else, because all that's contained in the contract, they call it the four corners rule. Anything that's in the four corners of the contract is what rules and what the court will look at.
Here's another great question. And I'm saying that because I'm asking it. If the inspection report points out something that's damaged, okay, the seller has put on this disclosure that they're not aware of this. Mm-hmm. But now this deal hasn't commenced yet. The buyer's aware that this exists. Mm-hmm. Does that now take the liability off the seller? Because it's like, okay, I might not know about it, mm-hmm. but it's on the table now.
And that's one of the strange things that, attorneys are going to have to kind of try to figure out. Like I have the Jersey deals, and in New Jersey, they actually all fill out that form, and it actually becomes part of the contract that's, signed by the buyer and the seller. So, the fact that you have on one side the seller saying, I don't know about that, and the other side, the inspection report saying, this is broken, like let's just call it the dishwasher. Okay, the dishwasher's broken. At one point you can say, all right, well, the dishwasher's broken. Is the seller going to do anything about it? Generally in contracts, it's, all appliances have to be in working order at closing. But, here it's saying, hey, the seller's saying it's not working, and we're saying, or it's working, or they didn't know about it. And here we're saying that my inspection team found that it's not working. So I really think that in contract law, it overrides. So if you write in there, hey, this is not working, the dishwasher is not working, at closing, it will be in working order, or my client gets a $500 credit for a new dishwasher. I think, and it's my belief that in light of what's going on right now, that is what's going to be controlling.
And I agree. But here's the problem that I see from an agent's listing agent's
Everyone's
perspective.
coming after me.
No. Well,
No, you're just like this unbelievable ball of knowledge.
right. And we're going to capitalize on that right now to the benefit of our listeners, of course. So what I foresee happening with this new Property Condition Disclosure Act is that buyers will have an unrealistic expectation of now they're going to get a perfect house.
I don't see that. You know why? Because if I had to explain it in a non-legal way, I would say you're not getting $500 and don't even pay attention to this. That's what I would say. And that is a complete non-legal way. Okay. That is me just being John Q, homeowner or home buyer. Okay. I would say, look, you're not getting the $500 anymore credit at closing. And you see this long form that the seller filled out, just ignore it. That's what I would not advise, because I'm not being an attorney right now.
Right.
But that's how I would approach it. Simply because I don't believe anything that a seller says if I'm the buyer's attorney.
Right. If you're opposing counsel, if you're on the opposite side of the table, you don't believe the other side.
I'm sorry. I mean, blame it on law school, but we have to look at everything as though they're our adversary, and we have to apply the the principles and the canons of viewing of contract law, and and then sometimes we just have to be our personal selves. And I'm a person too. Like, some people just think that I'm the lawyer, but I'm a person too. I've bought 3 homes, and I can tell you this, that if the seller told me that there's no foundational issues, I'd be like, yeah, okay, whatever, throw it out, right. And then just unfortunately not get $500 at closing.
I sign a contract. I waive my right to an inspection, and I'm buying the house as is. Is the seller completely off the hook?
Pretty much. Depends on what as is means. You're waiving an inspection. That just means that you don't know of certain things. Now, in the contract could be, all appliances will be in working order. Okay. If all the appliances are not working in working order, and that's the situation when you sign the contract and there's no clause saying so, then yeah, if something happens to the stove, the dishwasher, the fridge, and they're not working, then yes, okay, you can't get new ones. A lot of contracts, or most contracts, will say that all systems have to be in working order: heat, gas, the plumbing. If you do a truly as is contract and that's not in there, and one of those things doesn't work, yes, you're up a creek. And another thing, just leaks. Okay, I always write in. Hypothetically, other attorneys write in no active leaks. Okay, which means that you're buying as is, and they draw out leaks, because usually that's in the contract. If there's a leak, oh well. But generally, what as is means is that and this is the example that I give to all my clients. Perfect example. You see this wall here, okay? Doesn't have a hole in it. That means that right now I'm signing the contract, doesn't have a hole in it. By the time of closing, it's not going to have a hole in it. Okay? If it has a hole in it, we have problems. But let's say right now it does have a hole in it. Sign the contract, that hole is still going to be there, and the seller has no responsibility to fix that.
Because it's as is.
That's as is, as of the date of contract. So the seller has no obligation to make repairs other than, systems. Okay, so mechanical systems. So the garage door will have to be opening and closing. Windows have to open and close. Gas, if you have a gas stove, heat. Okay, plumbing. If air conditioning. Okay, those all are systems that have to be in working order unless you truly buy it as is.
Right? Well, even with the loan type, dictates what acceptable as is, right? I'll let Mr. Marcus do his thing, but in the case of FHA, has more requirements than conventional.
Yeah, because now we're going to get to the point where I mentioned it earlier, the appraiser comes in and is doing what I call a sight and sound inspection to make sure there's nothing detrimental. They start seeing exposed wires. For some reason, the FHA is really into chip paint, which I just have never figured out why. But if there's chip paint, they will make notes in that appraisal that it becomes a requirement. They will not allow me to close that loan until those things are addressed.
What about rails?
Oh, God.
Please don't get me started.
Don't get me and decks and rails.
So we're talking about this now, right? So I just did an appraisal this morning.
I'm talking about it.
I just did an appraisal this morning. Had an appraisal done on a property that I was the listing agent. Appraiser comes today. So Mr. Marcus said sight and sound. So check this one out. He's taking the photos. So the house has 3 bathrooms. So he walks in. He's like, okay, let me do the bathrooms on the second floor now. So he walks into the bathroom first. So the sellers are in the process of moving out. They're packing their stuff up. So the house is a little untidy. So he walks into the bathroom. He steps in, peeks around. So I'm like, what's up? Everything good? I don't normally talk to them. Hey, how's, being cordial. Nothing extraordinary. But that was peculiar behavior for me after witnessing countless appraisals. It's just the way he looked around as if he was checking. I'm like, you good? He's like, well, I was checking to make sure that was a shadow and not mildew. So I was like, what? It's fine, right? I know the house is untidy, but I know for a fact so I'm like, what? Because it took me back. I was like, mildew? He was like, yeah, if there's mildew in the photo, the bank is going to kick back the appraisal and I'd have to come back for reinspection, which I totally understand their whole reinspection part. And I'm like, so you're telling me there's mildew? I'm not. Remember, he's in the bathroom. I'm in another room because you're not allowed to be in the photos anyway. So I'm like, wait, he's like, no. It was just a shadow, but it looked dark and the bank has gotten very strict with mildew. I'm like, what? So I'm thinking to myself, mold I get right away. I get that. But he was very specific because there's a difference. And to me, the difference is mold is much more serious.
Oh, yeah.
Right?
Well, toxic mold.
To me, any mold is toxic, when it comes professionally. But mildew just means it's not clean.
Yeah, I mean,
my unprofessional opinion, because I am not a home inspector and or handyman or repairman. Okay, so I'm like, wait, what? It's dirty? So the bank's gonna have a problem with it being dirty?
That sounded weird.
That's why I'm bringing it up to you now.
I've never had something where they made comment to mildew, and same thing. 25 years of looking at appraisals, I've never seen a mildew required repair. And I'm not going to get on the case of appraisers, but I can tell you this. If you charge almost half the cost that it costs an appraisal to do a reinspection, I always found it very opportunistic for people to find said things that would require one to have to go back. Where if an appraisal takes an hour, hour and a half, 2 hours, A reinspection takes about 48 seconds, and they're making basically 50% of what an appraisal costs. So there are points in time, and every lender out there knows this, in regards to the agitation and aggravation that we've gone through in such a situation where a required repair is being set forth on an appraisal that we are looking at it, scratching our head, being like, there's no way these people are doing it. And then to try to have that conversation with the client on them having to pick up that additional cost. Like becomes
They don't want to hear it.
They don't want to hear it, and it becomes an uncomfortable situation. Most appraisers, as a footnote, are cool. Like they're not going to like sit there and play this game. But I could tell you, I've seen it where it's just like, I don't know if it's a tactic. I didn't know if it was them just not being great at their jobs, but I've been in that situation where I am in disbelief that these guys are making me have this reinspected, because we'll always ask that question. It's like, well, like, and I'll give you a perfect example. Okay. And this is actually warranted, but like ridiculously frustrating. The fuse box doesn't have a plate on it, right? So, okay, the fuse box doesn't have a plate on it. We all know that, like, we get the seller to buy the plate for the fuse box, take a picture, and I've gotten into arguments where how is that not good enough for this appraiser? Nope, gotta go back. You're going to charge my clients $200 to prove that a plate was put on a fuse box when I have a picture that matches the picture that you took of said fuse box. And we've all in the lenders world have gotten ridiculously aggravated, probably lost years off of our life, made a ton of money for drug companies prescribing blood pressure medication because we lose our minds on things like that. But like, it's just the nature of the beast.
Funny story. So that whole plate issue with the fuse box, I've actually had that happen where the appraiser came the same day as the home inspection, because they did the home inspection purely for informational purposes, which is what you do a home inspection for. Home inspector left the plate off. Appraiser comes in literally 20 minutes after. I have no idea. I'm outside with the buyer. I'm hanging out. I'm being all chummy. Appraiser comes in. I'm like, everything good? I hand him my paper. He doesn't have to take it. I'm just like, hey, these are the comps that I used when we wrote this up. He was like, great. Takes it, walks away. An hour, 2 hours later, I'm getting ready to go to dinner. I get a phone call. Bisendra, what the hell? I'm like, what happened? I was present. There's nothing was wrong. Everything was hunky dory. I got a picture of an appraisal, and in the basement, the fuse panel is missing the plate. I'm like, what are you talking about? I have a home inspection from the same time where the fuse I was like, oh shit.
He took the damn plate.
I was like, oh shit. I was like, give me until tomorrow. I called the home inspector. I'm like, look, we got a problem. He's like, and it's not anyone that I would recommend. This is the buyer's choice. I was like, look, we got a problem. You did the home inspection. You forgot to put the plate back on. He's like, oh, you want me to come back and do it? I was like, no, we got a bigger problem. The bank came, did the appraisal right after you, and you left the plate off, and it's in the photo. He was like, oh, just send him a new photo. I'm like, yeah, normally, but no. So now the buyer has to pay for the reinspection, $250.
Yeah, over $200.
Yeah, $250, and they're not happy about it. So I'm trying to mitigate this whole thing, and I'm sure you don't want to hear them chewing you a new one, because it was easy to figure out how it happened, right? Because even the listing photo doesn't have it in it. It's like, oh man, what do you think I should do? I'm like,
yeah.
I'm like, do you want to get it to the attorney or no?
You know what? To the attorney part. All right, this is me putting on my...
No, so long story short, I don't want to cut you off, and I want you to get to your part. But he wound up eating the $250.
It's brutal.
I was like...
Yeah.
And because he realized it was his mistake as a professional.
Yeah,
he was, I'll just pay the $250.
At least he stepped up on it.
No, that's a professional.
Yeah.
100%.
Yeah.
Right? He came back. He came back the next morning, put the plate on, took the photo. I sent it, right? And they're like, no, he's still going to come do the inspection. I was like, look, the inspector who made the mistake is going to pay for it. I'm going to put him on the phone. He's going to give you his credit card information. And he did it that way.
Wow.
But it's like at that point in time, that's when
that's a good man.
If I'm the appraisal company, I'm being like, you know what? You're doing the right thing here. I'm going to do the right thing here.
Yeah.
And they should have. Like
they should have.
The fact that they took that money, like I loved you, home inspector, for stepping up and owning that. And Mr. Appraiser Company, I am disappointed in you because like you saw somebody trying to do the right thing and you still took the money. And it, to me, like there is just a business ethics involved that very often gets overlooked for a dime. And that's one of those things. It's like, do the right thing, Mr. Appraiser.
And, you know, it's kind of funny because on my end, I get stuck with the CD. And, you know, I do a good job of going through it, you know, pretty thoroughly with the...
That's the closing disclosure to the layman person.
Yeah, sorry. It's the closing disclosure you get where you have to sign it 3 days before you actually close. And then once we get it in front of you at closing, you're pretty much exhausted and you just want to sign anything. But I will actually go through with it, you know, with buyers. And, you know, I go through that stuff, you know, even if it's a couple $100 here, a couple $100 there. But I feel like it is important because people need to know what their closing costs are. And also it educates me because, you know, I kind of, you know, people always ask me, what are my closing costs going to be? And most of the time my answer is, I don't know.
Right. You don't know.
Take it out of low, you know. But the best part is where, you know, I get educated and I could say, all right, well, I saw a loan, you know, and a deal similar to this and a mortgage similar to this at a rate similar to this. And, you know, so you're looking at this amount. And I feel that people are more confident about that, you know, so it's comforting. But the problem is obviously when certain things pop up, you know, not because of the bank's fault, but because they have to be disclosed according to law. But, you know, some things, you know, have to be shown on there. And one thing would be that 200 plus reinspection for the appraisal. And sometimes appraisals expire and they have to go back too. So
they're good for like 120 days. So if something like, and this is a perfectly good point when I'm doing a short sale. So in the cases where I do a short sale where I could be waiting like an exorbitant amount of time for to make the call. And I have one right now, even though in this type of market, I'm still head scratching how that's even possible. But I don't order the appraisal until I get that bank approval, knowing that like if I ordered at the beginning, fine and great, it would have expired already. It would have cost my client double them up on that appraisal. It's not worth it. Plus the fact that if anything has gone south back to that sight and sound inspection, they'll point out certain things because now we're talking about they went into contract 4.5 months ago.
Yeah.
So like who the heck knows what goes on? But here's with that new disclosure, what happens after that date for things that are existing in contract? Is that now like how does that work?
Well, you know, I think Bisendra touched on it before, where listings existing at that time. So, you know, and it's funny because Bisendra knows more than I do.
Oh no! So if the listing is still active,
because
on March 20th of this year, the seller has to fill that out. Yeah,
because the attorneys have been going back and forth because, you know, obviously we look over a law and we just argue it 20 different ways. You know, one way we look at it is as, you know, any deal that's currently pending.
Yes.
That's real property. You know, 1 through 4 family has to fill this out. But then other people are looking at any deal that has not gotten to the contract phase. You know, real property that's 1 through 4 families does not have to. So, you know, it does provoke some conversation. You know,
at a minimum.
Yeah, because again, as an attorney, you never want to say like, "Oh, I don't know," but I don't know.
I don't know.
Well, I don't know.
But we'll figure. But you'll figure it out, and we'll come back on another episode.
Maybe I got 3 weeks, so
we'll get there. All of a sudden, Jay's like crucified and hanging in front of like a state municipality.
People start boycotting.
Like, that's what happens when you don't know law.
Like this.
It's like I paid enough. I might as well.
So any last words of advice regarding the new changes to the property condition disclosure statement?
Fill it out.
To the best of your ability.
To the best of your ability, to the best of your knowledge. Don't lie. Okay. And I don't know. I don't know any advice for this because it's such
Your
a
advice
terrible...
should be talk to your lawyer.
Yeah. Really, it's such a terrible thing that's
When
happened.
your lawyer needs to go to his lawyer, we got problems in litigation.
It's like it's a terrible thing that's happened. So it's not
There's
like
a fox in the hen house.
Yeah, seriously, this is I don't know, but I'm not. As you can tell, I'm not a big fan of this. But then again, people from California, Jersey, or Wyoming,
other states have been doing it.
They're probably looking at us, and you'd be like, "What? You have to give $500 and that, and you don't have to do anything." So I guess this is New York catching up with the times.
Because there's the other little piece of it where it's just like, and we always get into this stuff, the cost of litigating versus like what you're getting out of that. So it's like most of these things, unless like this house is just like
falling
apart, like it's like I'm not going to sit there and do a lawsuit over a broken dishwasher. I mean, if I'm insane, maybe. Yeah, I mean, like
I was just going to say,
like I know that there's people out there that I'm discounting that will be these like crazy people, but I would think the average person is just going to understand that this stinks. I wish I knew that, but it is what it is.
Yeah. I mean, for example, I almost bought a house that had so many termites that it ate through a weight-bearing beam in the basement.
No way.
I'm dead serious. And so the whole den was sagging. So let's say, and the homeowners were elderly, and, let's say they just wrote, don't know. Okay. And let's say 5 days after I moved into that house, that place, the den collapsed into the basement. Okay. Now, if I were litigious, I'd be like, you know what? They wrote they didn't know. How could you not know? The den is sagging. If you went into the basement anytime in the past 50 years, you'd see so how do you not know? And you know what? If I were litigious, I may sue.
Man,
if I bought that house.
The more we talk about this, the more aggravated I'm getting about it.
See?
And only because I have the amount of experience that I have, and I'm truly sorry, not only for the newer agents that don't know, but also their customers.
Yeah.
And I'm going to tell you why. And I just had another awakening. This is like the third one for this conversation.
It's been great.
Right. So check this out. House property is listed for sale. Forget about who's representing who. It doesn't matter. House is listed for sale. Mr. Marcus is the buyer. He goes in. He's like, yeah, I like this house. You're his attorney. You call up. You get your home inspected. Seller has already completed the property condition disclosure. Let's just, for argument's sake, say unknown to everything. Mr. Marcus performs a home inspection. Home inspection comes back, finds 10 things. 10 things wrong. Provides a copy of his home inspection report to the seller. Seller says, nah, I'm not fixing nothing. Mr. Marcus withdraws, right? Walks away, goes to buy something else. Here comes Mr. First-time home buyer, right? Mr. First-time home buyer does not get a copy of the property condition disclosure. Does the seller have to update now their property condition disclosure?
What a great question.
Right? Do they have to now update it to know
because they know now?
Because now they know.
They know.
Wait for what?
Wait. Who is the inspector privy to?
The inspector's privy to the person who paid.
And who paid?
The buyer.
Is the inspector privy to the seller?
No, but the seller. My train of thought is the seller doesn't know the buyer. Hold on. Give me an opportunity. The seller has been put on notice by the previous buyer by providing the document.
But as legal counsel for the seller, you're going to probably advise them you're not looking at a home inspection.
Yeah, I mean, this home inspection was done by a drunk guy that I'm not privy to.
That could be that, but let's just say they used a very large inspection firm.
Okay. I wouldn't change my advice. You are privy to your knowledge, and that's it. You are not privy to someone who a potential buyer hired. Okay, you are not privy to them. You are privy to your knowledge and your knowledge only.
No, wait.
Now the buyer's attorney calls you as the seller's attorney, being like, "I have an inspection report that's saying there's a crack in this foundation."
Mm-hmm.
You are like sitting there, and again, you're just gonna play. Oh, he's rolling up his sleeves, ladies and gentlemen. Like,
there we go.
We thought we were ending it.
I thought
we're
that
just
was
going like, there's a new round.
Second win. Second win.
Okay. Now, who are inspection reports certified to?
We agree it's the buyer.
So does that mean it's certified to the seller?
We could definitely know that it's not.
It's not. Yeah.
But
And
you as legal counsel have
there
now
is
been
my-
told.
No. Okay.
I haven't been
So
told.
I'm gonna one up with
They
you.
told
I'm gonna
the buyer.
I'm gonna
not
one up
me.
you. Wait.
But if that attorney calls you up for like a repair inside the contract, being like, there's a crack in the foundation, we want that added to the contract, and we want like the seller to pay for it. Now the seller has rejected this contract, the buyer has gone elsewhere, and now the next buyer comes in. You have
I don't have knowledge.
Yeah.
I only have knowledge of what my client fills out. Okay, not even. I'm not even going to read it. I don't even want to read it.
No, I get it. No, but listen, two things. So the buyer's attorney submitted a copy of that buyer's inspection report to you and said, will the seller fix or correct any of these? And your seller said no, and that's what caused the buyer to walk.
Mm-hmm.
So
And then the
you
new
have been put
buyer-
on notice as counsel.
Not as counsel.
Yeah,
No,
you are
no,
representative
no,
of the
no, no,
seller.
no.
It was attorney to attorney communication.
But if it died at that point, it hasn't come.
No,
to me.
it died after the fact. It died after you got put on notice. Like these
And we're
line
talking
items.
about the next transaction.
Right.
Because now technically you, if not both you and the seller, know that there was a problem with this house.
So that's where
He's not
my-
gonna-
Where it's getting-
yeah.
we're not going to get what we're looking for out of him.
No.
But like when it comes down to it, we have a valid point right
that's
here.
what I'm saying.
We do. We have a valid point.
That's what I'm
but
saying.
I shouldn't take credit. You have a valid point.
No, but I'm gonna one
But
up
if
this.
I have noticed that there's a bee's nest outside, does that mean that I have to disclose that the house has a bee problem?
I would say yes.
Yeah.
That's exactly what you have to do.
No. So I'm gonna one up this.
All right, let's go.
So now, what type of mortgage is relevant? The appraiser. No, actually, it does make a point. It does make it relevant.
Mm-hmm.
The buyers applied for an FHA mortgage.
Okay.
The appraiser notes an issue that the seller did not disclose correctly. Wait. There's more to this. That the seller did not disclose correctly. Right? The buyer walks. The second buyer comes, and that second buyer is also has applied for an FHA mortgage. But the appraisal has been done.
And there's going to be a case number, so they're going to refer to that appraisal.
So let them. Okay.
Oh, dude!
The buyer borrower is
Mr. Marcus,
privy
you see where I'm
to the
going with this,
bank.
right?
I do.
Do you see where I'm going with this? Who has loyalty where?
The government has loyalty to the government.
Of course, they always do. But I'm talking about when it comes to who has, the inspection, who has the appraisal, who has, anything that was produced by someone other than the seller. Okay, because by giving something to the seller does not prove that in fact is true.
I agree.
I agree.
You're welcome.
I agree. But whether or not I agree
And
makes no difference.
If you notice, it has no duty of independent inspection to find out if something is wrong or not.
I'm you as the seller's attorney. I no longer allow them to send me an inspection
I don't
or an appraisal.
I don't want
I'm
anything.
I don't want anything from you. You want to tell me that this is it? I'll go back to my client and then I'll tell you that you can go take a walk and we'll let the next guy. Because it's like all of a sudden now I'm seeing a chain. And if like you're subpoenaed, like there's proof that you've received an appraisal from a certified appraiser. How are you going to deny the fact that you know that, like, in this email language saying point it out?
Nope. That does not
it's
prove.
Just nope. It's just nope.
Because at that time, who's the judge? Who's the jury? Who's proving that that's the, in fact, truth?
The American people, goddammit!
We the people.
It's literally literally the first words of the Constitution. Very interesting stuff.
This is good. This is going to be good.
This
Next
is
few
great,
months.
and it's like I gotta
defensive.
thank you, Jay, on this because it's just like you sat there in front of the firing squad, which we thoroughly enjoyed, and just like literally, just you're like Captain America, like you're just deflecting everything.
Wait for the attorneys to come comment and just badger all of my arguments.
Oh, dude.
It's okay.
We know you guys know. We know. All right, you're smarter than us. We know.
Yeah, that's okay.
Just kidding. You're not.
I'm cool. I'm cool with that.
They can think whatever they want. I'm okay with that.
Yeah, I'm fine. I'm good in my skin.
Wait, so this is a lot of good information for consumers.
A lot of good stuff in here.
And
You know,
we see it how it plays out. Like it's either going to be problematic or it'll just
yeah.
And I just want everyone listening to please communicate with the professionals. Use professionals, hire a good attorney, use a good bank, take the recommendations of your real estate
100%.
professional.
Yep.
Always get a home inspection. Do not be short-sighted by money, right? Because because the average sales price on the market, well, I'm not gonna, depending where you are, is in excess of $500,000.
I mean, here
in New York.
Yep.
In New York, the average sales price is in excess for a single family of 500. I think it's 536 if I
downstate.
Yeah.
Downstate,
Put
right?
an asterisk on that.
Thank you. So always use qualified professionals and listen to the advice of your attorney and your lender. They will give you the best guidance moving forward. And please do not ask for the $500 after March 20th, right? The date is March 20th, 2024. Do not ask for $500. Do not pass go. You will not receive $500. You're not collecting that money.
I mean, I'll ask for $500, but
yeah, you stand a better chance to collecting it than we do.
Yeah, good luck.
Okay. All right, Mr. I can't. All right, Mr. Kleiger, any last words or words of advice?
I'm gassed.
All right, Mr. Marcus.
Neuter and spay your pets, please. Love you, Bob Barker. Yeah, finally got the laugh right. Where's that been?
Okay, as always, we encourage you to reach out with any questions, whether it's regarding the PCDS, real estate transactions, mortgages, or legal matters. All of our contact information is in the description below. And remember, a well-informed decision is a powerful tool in any real estate endeavor. Let's unlock the doors to successful and informed transactions together. This episode was for informational purposes only and does not constitute legal or financial advice. Always consult with qualified professionals for specific guidance. Gentlemen, always a pleasure. This was a great episode. Thank you very much for being here.
Awesome.
Pleasure.
As we wrap up this real estate adventure, remember, every key we've shared opens a door to your property dreams. Thank you for joining us on Keys to the Castle. If you enjoyed the journey, please take a moment to leave a 5-star review. Your feedback means the world to us. Don't forget to follow us on social media for the latest updates. And you can find our contact information in the show description. Until next time, happy house hunting, and thank you for listening.